Eli. This is docket 1421-12-16, and it's $534.32 copay. I understand conflict counsel will have to be appointed. Mr. Head.
Yes, Your Honor, we've received a copy of the information alleging 6 counts, 3 of them a violation of 13 VSA section 2301, and 1 of them being a violation of 13 VSA section 1043A2. Actually 3 with that statute, and we would waive a further reading of the information, waive the 24-hour waiting period, and a plea of not guilty at this time, and as well as a recitation of the other Rule 5 rights.
Okay, thank you. State.
Judge, we're requesting that the defendant be held without bail under 7553. He is charged with 6 serious felonies, 3 of which are attempted second-degree murder charges. Those charges carry the possibility of a life sentence. Pursuant to that statute, the defendant can be held without bail if the evidence of guilt is great. And we submit, Judge, that that is the case. The defendant ran his vehicle into 3 people. It was witnessed by those 3 as well as another individual. We have statements from 4 folks who positively identified the defendant. He ran his car into 3 people. He ran his car over 1. The victim of the domestic case is the defendant's ex-domestic partner, Judge. She was the one who was injured the most seriously. When we look at these cases for risks of lethality, we see many of those factors in this case. The defendant assaulted his ex-partner with a deadly weapon. He did it in public, in front of other witnesses. He was under the influence of drugs and alcohol at the time, and he has in the past, Judge, she told me today, threatened to kill her by shooting her. And this all started because the defendant was jealous that she was dancing with one of the other witnesses and victims, Matthew Boynton, in the bar. We are asking the court to hold the defendant under that statute, and we're submitting that the evidence of guilt is great.
Well, Your Honor, we'd ask for conditions of release and a nominal amount or a reasonable amount of bail. He's got just 1 prior conviction, and that was for a misdemeanor trespass. There's been no failures to appear, and he was satisfactorily discharged from probation, and that was a number of years ago. We would propose, we have 3 people, 2 people especially here today, who are willing to supervise him 24 hours a day, 7 days a week. He is employed. One of the supervisors is a sister who's married to a co-owner of the carpentry business that he helps to operate, and they're willing to supervise him. If the court is going to hold him without bail, we'd ask for a hearing within 60 days, or the hearing in order to establish whether the evidence is great or not, as soon as possible, and that his assigned counsel be notified as soon as possible.
All right, so
I would just one other thing. I note that bail yesterday was set at $10,000, and that seems like a reasonable amount or slightly more.
So this fits a statute for Section 7553 in that it involves a potential life sentence. It is a crime of violence. There are at least 3 witnesses, 4 witnesses, including 3 potential victims, and an independent witness. There's cooperation from the police department in terms of the car involved and it being owned by Mr. Ely. And it's a domestic matter where the assault was committed in the public view. All are risk factors that the court finds sufficient for a hold without bail. So we will do a hold without bail. We'll set it for a hearing on the bail matter.
Yeah.
Darren Totten for change of plea.
What's the last name?
Totten.
Totten.